When Coalition Life petitioned for their writ of certiorari, the court declined to hear the case. Justice Alito said he would grant petition, but Justice Thomas is the only one who issued a dissent. Let's look at Thomas's view on Hill in a little more detail. Hill involved a 1993 Colorado statute which established buffer zones around abortion clinics. The law made it a crime for any person within 100 feet of any healthcare facility entrance to knowingly approach within 8 feet of another person without that person's consent for the purpose of passing a leaflet or handbill to, displaying a sign to, or engaging in oral protest, education, or counseling with such other person. Put another way, Colorado's law, still in effect today, prohibits unconsented sidewalk counseling within 100 feet of abortion clinics. Colorado enacted what is commonly called a buffer zone law. Actually, this is a double buffer, since within a 100-foot buffer of a healthcare facility entrance, you are not allowed within an 8-foot buffer of someone else, but only if you wish to exchange information. Shortly after the law's enactment, a group of self-described sidewalk counselors who sought to peaceably educate and counsel passerby about abortion and abortion alternative challenged the law under the First Amendment. This court upheld the law as a content-neutral time, place, and manner restriction. This is one of those free speech violations that the courts have adopted. As I pointed out, the Constitution of Colorado protects freedom of speech. Yes, you can be held accountable for the abuse of that right, but how is approaching someone to engage in that right abuse? The real question that should be asked is, who has the responsibility to stop someone's speech? Imagine if freedom of speech everywhere was treated the same way Colorado treats it around the healthcare facilities. Excuse me, is it okay if I wave and say hello to you? Do I have your permission to return this set of keys you just dropped? I'm sorry, is it okay if I drive past you with a sign on my truck? But the court claimed that the state could abridge the freedom of speech as long as it wasn't based on the content of that speech. Hill's errors were numerous. Whether Colorado's law applies to a given speaker undeniably turns on what he intends to say. A speaker wishing to approach another for the purpose of communicating any message except one of protest, education, or counseling may do so without first securing the other's consent. Nevertheless, the court deemed the law content neutral on the theory that it does not prohibit a particular viewpoint or a particular subject matter. But this court had never, and since Hill has never, taken such a narrow view of content-based speech restrictions. Buffer zones like the one at issue in Hill are obviously and undeniably content-based. Which brings us to the idea of content-based discrimination. See, it's one thing to establish rules for conduct in public that are content neutral. The use of bullhorns or demonstrations that obstruct traffic, for example. But that is not what the Colorado law did. Rather, it determined that if the content was oral protest, education, or counseling, and if the content was expressed outside of a healthcare facility, that speech was restricted. Justice Scalia could identify only one explanation for the majority's anomalous decision. The jurisprudence of this court has a way of changing when abortion is involved. Hill reflects the ad hoc nullification machine that this court sets in motion to push aside whatever doctrines happen to stand in the way of abortion. Yes, this was content-based restriction of free speech. If the content was pro-abortion, no problem. But if it was anti-abortion, Colorado wanted to censor it, at least outside healthcare facilities, which was generally used as a euphemism for abortion clinics.